Welcome to the Litigation War Room, where you will hear great stories and great insights to raise your litigation game and win more cases. Here's your host, litigation attorney, Maxwell Goss.
Gerard Mantese, welcome to the Litigation War Room.
Thank you. Great to be here.
Some of the most contentious lawsuits involve business breakups. Gerard Mantese has built a national reputation representing business owners, shareholders, and partners in cases involving oppression, breach of fiduciary duty, and other business conflicts. Gerard joins us today to share key lessons from his decades in the litigation trenches. We'll talk about mastering the facts from day one, dealing with hardball litigation tactics, and using common sense to persuade judges and juries. If you litigate shareholder fights or any high-stakes disputes, you'll want to hear what Gerard has to say. Now, Gerard, I'd like to start by just learning a little bit more about you, or helping our listeners learn a little bit more about you. Can you tell us about yourself and your firm and the work that you do?
Yes, I'm the CEO at Mantese Honigman PC, and I lead an outstanding team of attorneys and legal assistants who care deeply and advocate tenaciously for our clients in business owner disputes around the country. So we will handle any and all issues that business owners face, contract issues, real estate matters, corporate drafting, but we have a special focus on disputes that owners have with each other. And some people call this business breakup litigation, others call it business divorce litigation.
And Gerard, why this special focus on business breakup cases?
You know, Max, we think it is a privilege to handle owner disputes because you're dealing with a person's dream, perhaps a life's work, and to be entrusted with that dream and how that legacy ends up after a fight among the owners takes a special skill and a deep knowledge. And I've devoted part of my life's work to this important field.
Yeah, that is so true and really interesting insight. I mean, these are largely private companies, right?
Absolutely.
These kinds of issues don't arise so much in publicly traded companies. So these are family businesses, legacy businesses, people where the owners tend to be very close to the heart of things. Is that a fair characterization?
Exactly right.
Yeah. So the stakes are kind of everything for them.
Right.
Well, I'm excited to do this interview because I attended a presentation that you gave called 44 Ideas to Improve Your Skills as a Trial Attorney. And I thought our podcast listeners would love to hear some of your insights. Now, we won't cover all 44 here. We'd be here quite a long time if we did, but I do want to get just a few of the top lessons you can share and hear a bit about kind of the stories behind them and the cases where some of these things came into play, some of these lessons came into play. So why don't we just start at the beginning? Gerard, what do you do at the beginning of a case, and why is it important?
I think the most important thing is to listen to the client and hear all of the facts and perspectives that the client has. We think that's the most important resource. If the client has lived this issue and these disputes, so I think you cannot spend enough time with the client taking down everything she or he has to say. And of course, reading the entire file. Don't forget the contract. Start there, start with the file. The law changes slowly. And after a decade, you can master most of the law. But the facts in every case are always different. And these have to be given special attention. When I'm at a meeting, I'm taking detailed notes because I know that every morsel of fact is gold. It can spell the difference between winning and losing. So that's the first thing, is talk to the client, get the fact, read the entire file scrupulously.
And then as the case begins to unfold, can you tell us what are some of the key things that litigators should be doing to build their case as they head towards trial?
Well, let me say the fundamental driving force is caring. If you care about your client and this litigation, you're going to meet with those extra witnesses. You're going to do some extra research. You're going to prepare for that deposition and that motion with a fierce dedication. So on depositions, don't waste a second. Take the full time, be curious. I had one case, I'll call it the B versus G case. shareholder dispute. My client owned 25% of a couple companies, and I kept inquiring of the controlling shareholder why it was fair that he was making 100 times more than my client, who owned 25% of the company. And I kept asking in different ways, and he became flustered and finally said, "Look, that's just the way it is. Those in control get all the money, and the shareholders get $1.50 a share." So we ended up
Talk about gold. That's quite a nugget.
we ended up trying the case, played the video for the jury, and I'll tell you, they just stared and glared at that guy, and the defendants could feel that the jury was not happy with them. And on the fifth day of trial, they offered us everything we were asking for, 8 figures, and a full settlement of that case.
Wow, that's amazing. I mean, that really illustrates what a game changer depositions can be. You said a couple of things that just captured my or grabbed my attention. One was the emphasis that you started with on caring for clients. That's so true, and you don't hear that all that often, at least in the space that you and I inhabit of business litigation, IP litigation, that kind of thing. I mean, I've certainly found in my practice, and we try to make it an emphasis in my practice that, hey, these might be people of significant means and a fair amount of power, but they're also human beings. And oftentimes they have built these companies themselves, or they have inherited it from a family member and run with it. And these disputes they have are often with close friends, spouses, children, parents. They want to know that you're going to come in and kick butt, but I find they need a lot of personal care too. They're human just like anybody else.
They do. The clients want to know that you care, that you're thinking about their cases even after 5:30 p.m., that you're coming up with ideas to resolve the case as quickly as possible, as efficiently as possible. But Max, I think it's important to emphasize that caring and being a strong advocate for your client does not mean being an idiot and a loudmouth. In fact, that's counterproductive. I found that people who think they can bully you and steamroller you by yelling at you and using profanity and engaging in sharp practices, it's counterproductive and it doesn't work.
Yeah.
And class and professionalism always prevail. It's always the right thing to do, and it's always the strategic thing to do for your client.
Well, you've certainly gotten that right. And I'd like to come back and drill down on that a little more. One other thing that jumped out was how you said, don't waste a second in a deposition. And I think when you gave the presentation I saw, you said, take the full 7 hours of the deposition. And that's contrary to some of the prevailing wisdom. I mean, most attorneys, I think, do take, at least in business litigation, do take a lot of time and often take the whole 7 hours. But at least from what I've seen in the books that you read, the podcasts I listen to, a lot of the leading lights say, get in, get out, get your nugget and go. Don't waste the client's money. Don't belabor things. So I'd just love to hear a little bit more about why your perspective is take that whole 7 hours.
Absolutely. I think at trial, you want to have that strategy of getting in, being crisp. Jurors and judges love that. It's so effective not to waste a word and to be clean and crisp in your questioning. But at a deposition, that's exploratory. There is so much you don't know. And if you spend some time being curious and running down every answer, you don't know where it will lead you. So I'm a strong advocate of really taking the full amount of time and exploring every single thing that this witness knows about the case. You never know. It could be the 6th hour and the 50th minute where all of a sudden you got the morsel of information that you didn't know that could really crack open the entire case. I've seen it happen many times.
Absolutely. And it's your one shot in most cases.
Absolutely.
So that's kind of the factual side of building a case. Can you tell us a little bit about developing the case from a legal perspective?
Yeah, I think it's important not to be complacent in your knowledge of the law. I said that the law changes slowly and you could master most of the law in maybe a decade, but that doesn't mean there aren't nuances. And I think it's really important to keep digging. We have found cases that can spell the difference between winning and losing. For example, in Frank v. Franks, one of the leading shareholder cases in Michigan,
Yeah, and I was just going to say, Gerard, you've got an advantage in learning the law when your cases make the law in this area.
Yes, we have made a lot of great and important law. We handled a lot of the most important cases in the shareholder and LLC member sphere. And one was Frank T. Franks. We tried that case to the judge, two cousins fighting over a company and over the benefits of a company. And the defendants stopped paying dividends at some point, and they kept relying on the business judgment rule in their actions. We did some deep research and found that the business judgment rule was never intended to apply when the director's own self-interest was being advanced. And we explained that to the judge, and the Court of Appeals actually said when there is oppression, the business judgment rule is irrelevant. And we've seen that in other cases, Robinson versus Lagenbach in Missouri, Supreme Court case. So I think it's important to not assume you know the law, read the case, and keep digging for the correct precedent to support your case.
Well, and the law is so vast that even if you're an expert in a particular niche, there's just no end to what you can learn about it.
Absolutely. I think a lifelong learning mentality is important. I'm reading treatises right now that discuss Delaware, New York, Texas, Florida law. I myself I took the Florida bar a couple of years ago because I just love learning and I wanted to be licensed there. I'm licensed in Florida, New York, Michigan, and Missouri. I think one has to continue to move forward. On the side, I study music theory because I just think there are so many connections between art and law that I'm continually amazed at how the body of knowledge comes full circle sometimes.
Now, that is an interesting comment, and it sounds like a whole podcast episode in itself. So maybe we'll have to bring you back to talk about the connection between art and law. Let's turn, though, to you mentioned juries and judges and persuading them. What's your top pointer for the art of persuasion?
I do think it's important to cut to the real issues. More words don't equal more effective advocacy. I've talked to so many juries, they want you to get to the point. So when you have so much extra words and concepts and issues and detail, the important points can get lost. So I think you've got to streamline and hone your examinations and your opening and closing arguments. The second thing is keep your common sense. I had a case, Wojcik versus McNish, that I tried to a jury. There, it was a shareholder fight, and the shareholder agreement said a departing shareholder gets bought out pursuant to a certificate of value. Well, the parties didn't have a document called certificate of value. And at the trial, the defense counsel said to the jury, I know it's difficult, members of the jury, but send away Mr. Wojcik with zero because there is no certificate of value. And I implored the jury to use their common sense. And even though there wasn't a document that had that title on it, the parties had an appraisal done valuing the shares. And I said, that is the certificate of value, but they didn't call it that. And the jury gave us everything we asked for pursuant to that appraisal. So I think judges and jury want to achieve basic fairness, and they will use their practical common sense in doing so.
Yeah. And there's a real connection there between common sense and that basic idea of fairness. If you say, well, look, we should be able to cut these guys out just because they don't have a piece of paper that says certificate of valuation on the top. I mean, that's just contrary to our sense of justice and just common sense, as you put it.
Yes, absolutely.
I also like what you said about keeping it short, getting to the point. That's what juries like. That's what judges like. And I think as litigators, the temptation is to be over-inclusive in our briefing and in our arguments and in the evidence we present. I think because we're paranoid about missing something. We don't want to waive something on appeal or leave a box on our elements chart unchecked. But it leads to a lot of really bad lawyering and ineffective persuasion, doesn't it?
It can. It's a needle that you have to thread, and you've got to obviously not leave anything important out, but you can't burden people's attention with too much information. Studies have shown, that if you have too much information, jurors will lose the real gold. They've done that research in commercials. If a commercial tries to cover too much territory, the essential message that the advertiser wants to impart to the listener will get lost.
Yeah. Yeah.
And that's why when some of these drug companies are talking about the symptoms or the risks of a particular drug, they'll throw every possible risk in there so that you ignore the heart attack and the stroke that might happen.
Right. They take advantage of that very same thing, but use it to their own advantage, right?
Right, exactly.
Yeah, that's really interesting. Good observation. The other thing I want to turn to and talk about is some of your thoughts on dealing with hardball litigation tactics. You mentioned it earlier, and I know you've got some interesting stories here. So what can you tell our listeners about how to handle the litigators who just don't behave in a professional, courteous, or ethical manner?
Yeah, Max, I think the very few who engage in sharp practice and, just rough treatment of the process, they can make the practice distasteful at times. It doesn't happen often. And there's no easy answer, but I think what's important is not to fight fire with fire. Don't equate being abrasive with being effective. So I think you have to not get distracted. At times you can mention it to the court. We had a case where opposing counsel nearly smacked me at a deposition. I was asking really penetrating questions of this witness, and during a break, he comes within 10 inches of me. He calls me an effer, and my client was like getting worried. My client comes close to me to protect me because you could tell opposing counsel had just kind of lost it, and he came so close to shaking his fists and smacking me. And
Wow.
I didn't respond, kept on point after the break. And I sent a letter to the person's general counsel at a larger firm, told him what happened. To the credit of that firm, the CEO wrote me back and apologized. So I think you've got to try to ignore it. Don't let it put you off your game. I had another case where my client, who was a woman in litigation with her brother, and she came home one day and found a dead deer in her driveway. And she was certain it came from her brother
Oh
and
my
a
gosh.
shareholder fight. Yeah, it was awful. We supported her, brought it to the court's attention, but we didn't let it deter us or distract us. So I think, like I said, class and professionalism always prevail. They're always more effective.
That deer in the driveway story, I mean, that's Godfather level harassment. That's like putting a horse head in somebody's bed.
Yeah.
I think there's a balance there as litigators. On the one hand, we want to have passion, we want to have engagement. Our clients want to know we care, and we're not putting on an act. We do care. We get very involved. But sometimes it seems like litigators get a little, maybe a little too close and forget that at the end of the day, they're fighting for somebody else, not for themselves. And, I just have to wonder if that is one of the things that contributes to a lack of civility and professionalism is they have too much emotion wrapped up in these cases when really at the end of the day it's not their case, it's their client's case.
And judges don't appreciate it. We're hearing more and more that judges are not liking animosity and the personal back and forth with the lawyers.
Yeah, that's true. And we are hearing more and more of it. Well, to kind of tie things up in a bow, a question I have for you is what's one thing every business attorney needs to know to litigate these cases more effectively?
I would say a couple things, Max. Along with the idea of lifelong learning, I think if a business attorney wanted to devote a little extra time to some outside study, I would really recommend studying valuation. Because when you think about it, when you're splitting up a company or an empire, not everybody might have the same idea of what something is worth. And that issue of what businesses and what real estate and what operating companies are worth, what their value is, allows for some creative lawyering and some win-win resolutions. We know that most cases get resolved before a trial. So studying concepts of fair market value and the market approach and the income approach to valuing businesses really will pay dividends. In fact, a few days ago, I took the test to become certified as a certified valuation analyst.
Mm,
It was a 5-hour test
that's really
with
cool.
400 questions. I studied a few months and I really upped my game in that regard. It was a very enjoyable process and I feel even more empowered in that sphere. The other thing I would recommend, Max, is don't overlook the tax issues. The tax implications of a transaction can mean the difference of millions of dollars. And we have one case, I'll call it the case of the three brothers. They were fighting over an empire worth tens and tens of millions of dollars, real estate and operating companies. And they couldn't agree on anything, except they could agree that they didn't want to pay one more dollar in tax than they had to. So we brought in tax professionals who came up with an idea that would divide the empire in a way that would mean millions of dollars of tax savings. And everybody loved that, even opposing counsel. And that was the solution to resolving the entire case. So I think bringing appropriate tax people in can be just wonderful.
You know, it's funny in business cases and business divorce cases in particular, both those issues, valuation and tax issues, it's really easy as an attorney to just punt and just say, I'm not an expert on those things. I'm a lawyer. Go talk to another professional. And often that can leave clients, in the dark, and being able to add some value on that score, it's just something that makes you just a much more effective advocate for your clients. And I love that you got certified as a valuation professional. I guess there's one more question that comes to mind on this score is, when is the right time to look for kind of outside expertise like these tax professionals, and what's a good way to bring them in to a case?
I think you should develop a list of people that you respect, tax attorneys or CPAs, valuation people, appraisers, and you should recommend, particular names and make sure they're there at important events like the mediation or like meetings where you're planning strategy, because a tax structure can really make a big difference in the value that your client ultimately receives.
Yeah.
One thing I think is important in being a business attorney is to look at the issues in many different ways. And I have creativity sessions on the weekends where I'll spend a half an hour going through my main case and ask myself, am I looking at everything in a strategic way? Is there another way to accomplish the client's goals? Is there another fact witness we can talk to? Is there another legal angle? Have I read read the contract again? Sometimes when you read the relevant agreements later on during the life of the litigation, you have an aha moment. I see how that fits in here. So I think it's important to keep driving forward. And my goal, Max, is to resolve a case as successfully and as quickly as I can, because time is money. And the longer these cases drag on, the more time the client spends, the more money they have to spend, and the more psychic energy they lose. So one of the first things I do is I move for a trial date as early as possible. I tell the client that I want them to know that I'm trying to get this case resolved as effectively and efficiently as I can. And during that process, it's important to work with them, to have a continual dialogue. I've seen situations where a client will come to me unhappy with a prior attorney because they say, I feel like I'm an intruder. They don't listen to me. They don't tell me what's happening with the case. I think that's a big mistake from so many different perspectives, not the least of which is your client has the information. They lived the disputes.
Right.
And you want to hear from them. You want to hear their ideas. You can't be so arrogant to think that they cannot contribute insight and strategies. So I think it's important to treat them as a partner as you go through the process.
For sure. And I think the flip side of that is they want to see that you are mastering the facts of their situation. Something I often tell clients is, look, you've lived with this for the last 3 years and I'm coming in cold, but I will know your case backwards and forwards, perhaps better than you do by the time we finish this case. And I think they like to see that, and they like to be a resource, and they like to share the facts, but they also like to see their attorney themselves mastering it and looking at it creatively. And there's so many takeaways here, but in particular, the thought, Gerard, of taking these, I don't know what you called it, a creativity session, where you just sort of sit back, try to think outside the box, to use a cliche, and say, is there something I missed, or is there some new angle I can take? Is there some new strategy that can kind of break through break a log jam or add new value to this case. Setting aside dedicated time for that, I mean, that's just a great idea.
Yeah, let me just underline that, Max. Having quiet time with a case just brings genius, brings brilliance. I'm a chess player, and I found that when I just have some quiet time and I'm looking at the chessboard when I'm playing people in other countries on chess.com, and if I spend just a few minutes and then come back maybe the next day, it's like, I see it. I get where they're going. And it's the same way with your cases. If you just, apart from the emails and the hubbub and the hecticness of the practice of law, just devote a little time on a weekend, you really have that quiet time really allows you to develop new ideas and new strategies.
Well, I think that is the perfect note to end this interview on. This has been tremendously insightful and valuable and interesting too. I love the war stories you shared with us today. Gerard, if listeners want to learn more about you and your firm and your practice, where can they go?
ManteseLaw.com is our website. I love my work. I'm practicing 7 days a week. I do think it's important to have hobbies. I love music, rollerblading, biking, but I do love my work. So I'm available 7 days a week, and we have an amazing team. I appreciate
that's amazing.
time.
And you do have an amazing team. So, Gerard, this has been really fun. Thank you so much for sharing your insights today on the Litigation War Room.
Thank you, Max. I enjoyed it.
You have been listening to the Litigation War Room with litigation attorney Maxwell Goss. Maxwell Goss brings forceful advocacy and creative solutions to trade secret, IP, and business cases in Michigan and around the country. For show notes and more episodes, please visit us at thelitigationwarroom.com. If you enjoy the show, please be sure to subscribe, rate, and review wherever you get your podcasts. Thank you for listening. The Litigation War Room, including the podcast and all website content and social media, is for informational and entertainment purposes only. This podcast does not provide legal advice and does not give rise to an attorney-client relationship. All views and opinions expressed on this podcast belong to the guests expressing them and do not reflect the views and opinions of the Litigation War Room.